case of State of Ohio versus Mary L. Burrington, case number 25 CR 000297. We're here today for purposes now of a change of plea. It is the state's understanding in speaking to Mr. Perez and Mr. Perez having time to speak with his client that with the following amendment that there would be a written and oral plea of guilty today. If that plea was forthcoming and the court accepted that plea, then we would ask for the case to be referred for a pre-sentence report investigation as well as a drug and alcohol evaluation. I have indicated to Mr. Perez that I would enter into a joint recommendation for community control as well based on some of the circumstances. The plea would be to a lesser included offense of count 1, that being a felony of the 4th degree in violation of 4511.19A1A. If that plea is forthcoming and the court accepts that plea, then at the time of sentencing, I would move to dismiss count 2.
Thank you. Give me 1 second, please. So this is the old DUI prior to the amendment in April?
Yes, Your Honor. This is on February 27th.
All right, Mr. Perez, does that all sound accurate?
It does, Your Honor.
Ms. Burrington, were you able to hear what the prosecutor just had to say regarding what she believes your intentions are here at this time?
Yes, Your Honor.
She indicated to the court she believes it's your desire to withdraw your previously entered plea of not guilty to count 1 and enter a plea of guilty to a lesser included or reduced offense of count 1, being operating a vehicle under the influence of alcohol, a drug of abuse, or a combination of them, a felony of the 4th degree. Count 2 would get dismissed. We would defer or continue sentencing to a later day to get some evaluations and reports completed. Come back on a future day for sentencing, where at that time it's been represented that a joint recommendation for community control sanctions will be recommended by both sides. Is that your understanding of the discussions that took place between your lawyer and the prosecutor, most importantly what you want to do today?
Yes, Your Honor.
Well, before I can accept your guilty plea, I need to make sure you understand everything going on here. I need to make sure you understand what it is you're charged with and pleading guilty to, the rights you have that you give up by pleading guilty, as well as all the possible penalties you face. So in order for me to determine all those issues, I need to ask you a series of questions. If at any point when I'm asking you any of these questions, if you're unsure or unclear of anything I'm asking you, if you need anything repeated or clarified, if you'd like a moment to talk with your lawyer to ask him questions, or even if you want to ask me questions, make sure you let me know that, because I need to make sure you understand everything going on, all right?
Yes, Your Honor.
All right. Well, let's get started then. How old are you?
59.
Are you able to read and write the English language?
Yes, Your Honor.
Do you have any difficulty with that or difficulty understanding what you read in the English language?
No, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Now, before you came into court here this morning, have you had any drugs or alcohol of any kind?
No, Your Honor.
What about in the last 48 hours?
No, Your Honor.
Not even prescribed medication, nothing?
Prescribed medicine.
Oh, yes, Your Honor. I am on prescribed medication.
What prescribed medication would you have, or what?
Lexapro and Wellbutrin.
Anything else?
I took some Motrin.
Took some what?
Motrin.
Motrin?
Motrin, Judge.
Oh, Motrin. I'm sorry.
Yeah, I think it's ibuprofen or something like that.
Yeah. So just those 3 in the last 48 hours?
Yes, Your Honor.
Okay. And the reason I asked that, I want to make sure you're of clear mind right now. You're not under the influence or being impacted by any type of illegal drugs or even prescribed medication. So does any of these medications that you've taken, are they affecting your ability to understand or appreciate where you are or what's going on around you or anything like that?
No, Your Honor.
Now, you would have received a copy of the indictment in this case. It looks like you got it sometime around the very beginning of June or beginning of June. You remember getting that, the document that sets forth the charges?
Yes, Your Honor.
Now, in that indictment, you are charged with 2 counts. You're pleading guilty to a reduced charge of count 1. How are we doing that? We're just going to say that she's got 3 in the last
Your Honor, it would be, for the F4 would be either 4th or 5th in 10 or 6th in 20. So we're looking at.
4th or 5th and 10?
It says 4th or 5th in 10 or 6th in 20. So
It's got to be 3 or 4. Isn't it 3 or 4?
This is for 6.
No, it's 4 and 10 or 6 and 20.
And would be her 6th.
In 10 or in 20?
In 20.
So that's what we want to do it?
Plus. That's how we'll do it.
So what is it? Is it 5 and 20 is what makes it or 6 and 20?
6 and 20, or it makes it a felony, or 4 and 10 makes it a felony.
A felony 4, right?
Each
Yes, Your
one
Honor.
of them do that, yeah.
All right, so what I'm going to read to you at this time is what you're charged with. This is not what you're pleading guilty to, but what you're charged with. In count 1, it's alleged on or about February 27th, 2025, in Mentor on the Lake County, Ohio, that you did operate a vehicle under the influence of alcohol, a drug of abuse, or a combination of them. It's further alleged that you previously were convicted or pled guilty to a felony OVI violation, that being here in the Lake County Common Police Court on September 30th of 98, as well as June 10th, 2013. So that conduct with the prior felony OVI conviction constitutes the offense of operating a vehicle under the influence of alcohol, a drug of abuse, or a combination of them. It's a felony of the 3rd degree. And that's what you're charged with. That's not what you're pleading guilty to. For purposes of the plea today, the state has agreed to amend the 2nd paragraph that I read to you about the prior felony conviction, delete that, and allege that you have 6 prior convictions in 20 years. And the significance of that is that it reduces it from a felony of the 3rd degree, which requires mandatory prison, to a felony of the 4th degree, which is less serious, and it doesn't require mandatory prison. The penalties are much less serious than what they would be for a felony of the 3rd degree. So do you understand the difference between what you're charged with and what you're pleading guilty to?
Yes, Your Honor.
Any questions for me about that?
No, Your Honor.
Now, there is a second count of this indictment that's being dismissed pursuant to the agreement. Is that your understanding? Count 2 is being dismissed?
Yes, Your Honor.
Any questions about that charge, even though it's being dismissed?
No, Your Honor.
Okay. Well, then before I can accept your guilty plea, I need to make sure you understand all the rights you're giving up by pleading guilty, and you first of all have a right to a trial. Now, a trial could be to me as a judge, where I listen to the evidence and I make that ultimate decision whether you're guilty or not guilty, but you also have a constitutional right to have a jury trial, and a jury trial would be in front of 12 citizens here from Lake County who would listen to all the evidence presented. Those jurors would weigh and consider that evidence, and then those jurors would make that decision. That decision reached by the jurors would have to be unanimous, which means all of them, all 12 of them, would have to agree together one way or the other, whether you're guilty or not guilty. Do you understand that?
Yes, Your Honor.
Do you understand by pleading guilty you're giving up your right to have a trial?
Yes, Your Honor.
Now, if you had a trial, you'd have the right to have an attorney represent you at that trial. If you could not afford an attorney, the court would appoint one for you free of charge. Do you understand that?
Yes, Your Honor.
Now, if we did go to trial, the prosecutor here would be representing the state of Ohio, and she would have what we refer to as the burden of proof. With her having the burden of proof, what that actually means is that it is her job, or she bears the responsibility or the obligation, she bears the burden of proving you guilty before you could ever be found guilty. You're presumed innocent of these charges, and that presumption of innocence stays with you and remains with you until the state, if at all, was ever able at a trial to overcome that presumption and prove you guilty. Do you understand that?
Yes, Your Honor.
Now, when I speak of that burden of proof, since this is a criminal case, that burden is what we refer to as proof beyond a reasonable doubt. That's the highest burden there is in our justice system. What that actually means, it's the amount of the evidence and the quality of that evidence the state would have to present at a trial to prove you guilty. So in this case, the state would have to present evidence to prove each element or each part of the charge I just read to you beyond any reasonable doubt before you could ever be found guilty of that charge at a trial. Do you understand that?
Yes, Your Honor.
Do you understand by pleading guilty you're giving up your right to make the prosecutor prove you guilty beyond a reasonable doubt?
Yes, Your Honor.
Now, in order to try to do that, if we did have a trial, the prosecutor would call witnesses to come into the courtroom to testify for the state, and they'd be answering questions from the prosecutor. Once those witnesses answer the prosecutor's questions, then your lawyer would have the right on your behalf to ask those same persons questions. We call that cross-examination. He could ask them anything he wanted to within certain rules. Do you understand that?
Yes, Your Honor.
Do you understand by pleading guilty you're giving up your right to cross-examine or confront those witnesses that would come in here and testify against you?
Yes, Your Honor.
Now, you'd also have the right at a trial. You could call your own witnesses to come into court to testify for you if you wanted to and answer your lawyer's questions. Now, you don't have to do that. You're not required to do that. But you have a right to do that if you wanted. Do you understand that?
Yes, Your Honor.
And you further can request the court issue an order. We call that order a subpoena. What a subpoena would actually do is it would force or make someone come to court and testify for you and answer your lawyer's questions if they weren't willing to come in voluntarily on their own. Do you understand that?
Yes, Your Honor.
You realize you're giving up that right.
Yes, Your Honor.
Now, you'd also have a right at a trial. You could choose to testify on your own behalf if you wanted to, but you do have a constitutional right not to testify if you don't want to. That's a decision or a choice that you would have to make. Do you understand that?
Yes, Your Honor.
And since that's solely your choice, what that really means then is that nobody else could force you or make you. Nobody could compel you to testify against yourself at a trial if you didn't want to. I can't make you testify. But more importantly, the prosecutor here, she's not allowed to call you as a witness and make you get up on the stand and answer questions and testify. Your own lawyer can't make you testify if you didn't want to. Do you understand that?
Yes, Your Honor.
Further understand that if we went to trial and you were found guilty, you would have the right to appeal that guilty finding. By pleading guilty here today, you're giving up or waiving any right you have to appeal a guilty finding that I will make to this reduced charge, as well as any other issues that you could have raised or brought to my attention or that you did raise. So, for example, this suppression hearing that we were scheduled to have and the motion that you raised, that's going to be withdrawn. We're not going to address that issue, and you're not going to be able to address it at any later time. You understand that?
Yes, Your Honor.
All right, well, do you have any questions at all about these rights we've just discussed? These are all the rights you have and all the rights you give up by pleading guilty. Any questions?
No, Your Honor.
Do you understand them all?
Yes, Your Honor.
Do you still want to plead guilty?
Yes, Your Honor.
Do you understand a guilty plea is a complete admission of guilt? It means you're admitting to the facts being alleged by the prosecutor. We're not going to argue that you didn't do this or it's someone else's fault or anything like that. Do you understand that?
Yes, Your Honor.
Further, as a result of pleading guilty, the effect of that plea is that, first off, you'll be found guilty by the court of this lesser charge. And then secondly, you'll be sentenced. Now, we won't do that today. They'll be down the road of 4 to 6 weeks or so, but you'll be sentenced as a result of pleading guilty. Do you understand that?
Yes, Your Honor.
Now, as far as sentencing goes, you're pleading guilty to this reduced charge. It's a felony of the 4th degree, OVI. This is punishable by a possible term in prison of a minimum of 60 days. And then if I were to if I was to determine that more prison time was warranted, I would then select a number between 6 months and 30 months. So the minimum is 60 days. Then it would jump up to, if I was going to give more, up to at least 6 months, and then it could be every month in between 6 to 30. You understand that?
Yes, Your Honor.
Now, prison's not mandatory in this case, but if it was going to be prison, that would be the range we're talking about. You understand that?
Yes, Your Honor.
Now, are you currently on probation or parole or PRC or any supervision to any other courts or agencies?
No, sir.
Do you have any other charges pending against you anywhere?
No, sir.
So if a prison term was imposed in this case, upon your release from prison, you could be placed on what's called post-release control. It's sometimes called or referred to as parole. It's a period of supervision you would be on after you completed whatever the prison sentence was. In this particular case, it could be up to 2 years. Now, again, it wouldn't be mandatory if you went to prison. It's up for the parole authority to determine that. I don't have any say in that. Do you understand that?
Yes, Your Honor.
Excuse me. And further, if you were put on post-release control and you were violated any of the conditions of your supervision, the parole authority can return you to prison as punishment for violating the rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half of whatever the prison term was imposed by the court. Do you understand that?
Yes, Your Honor.
Now, aside from this possible prison sentence that I have mentioned, there's other sanctions that could be ordered. There's a mandatory fine that's required in this case of at least $1,350 that must be imposed, but I could fine you up to $10,500. So anywhere between $1,350 and $10,500, a fine will be imposed in that range. Do you understand that?
Yes, Your Honor.
You could also be ordered to pay court costs, reimburse the county for any costs of confinement, community supervision, or treatment if any of that were applicable. Do you understand that?
Yes, Your Honor.
There's also a mandatory driver's license suspension, which I'm required to impose of at least 3 years, and I could suspend your driver's license for life. Do you understand that?
Yes, Your Honor.
Also, any right, title, or interest you have in the motor vehicle that was being operated at the time will be forfeited to the state of Ohio. Now, I understand the vehicle was returned to the creditor, it says here, but so there won't be any interest that you have in it any longer, but I will order that at sentencing. If there is any interest, that would be forfeited. Do you understand that?
Yes, Your Honor.
Now, a few moments ago, well, just let me make one other comment. So I need to make sure you understand the maximum prison sentence that you could face. I'm required to make sure you understand that. The maximum prison sentence you could face would be 30 months in prison. You understand that?
Yes, Your Honor.
Okay. Now, I just explained to you the possible prison sentence you face. I use the word possible because with this reduced charge, prison's not mandatory. You are eligible for probation, or what's called community control sanctions. Do you understand that?
Yes, Your Honor.
Now, just because you're eligible doesn't mean you automatically be put on community control sanctions. It means I'll consider that if that's what you're requesting. It appears that you are, from what was represented. I'm going to look at all the information presented, then I'll make the decision I think is the right thing to do. Do you understand that?
Yes, Your Honor.
Okay. Now, if you are put on community control sanctions, it could be for up to 5 years of supervision. And as the judge, I have the discretion or authority to order a wide variety of rules and conditions for you to follow. Now, one of the conditions that are required, I would be required to impose as a condition of community control sanctions is that you serve a term of local incarceration of at least 60 consecutive days. So if you're not sent to prison, a mandatory term of local incarceration of a minimum of 60 consecutive days is required. Do you understand that?
Yes, Your Honor.
Now, I could order more time of local incarceration, up to 1 year of local incarceration. So anywhere between 60 consecutive days and 1 year of local incarceration would be ordered if you were put on community control sanctions. Do you understand that?
Yes, Your Honor.
I also need to advise you that if I sentence you to prison, I do have the authority that after you complete whatever the prison sentence is that I've imposed, that I could put you on community control sanctions at that time for up to 5 years. Do you understand that?
Yes, Your Honor.
Now, at that point, you would have already served the incarceration point. You wouldn't have to do 60 consecutive days at that point. But any other conditions I ordered, you'd have to comply with. Do you understand that?
Yes, Your Honor.
Now, if you are on community control sanctions, that this court never violated any of the rules or conditions of your probation or supervision, we would have a hearing here in court to see if you're what's called a probation violator. If it was determined that you were, I could extend your probation up to 5 years if it wasn't originally 5 years. I could impose more restrictive sanctions against you, which could include more local jail time. Or I could terminate your community control at that point and send you to prison. If I did that, it could be 6 to 30 months in prison, up to 30 months in prison. You understand that?
Yes, Your Honor.
All right. Lastly, when we do come back here for sentencing, you'll have the right on that day to say anything you want. Anything you'd like me to know or consider, your lawyer could speak on your behalf. He's allowed to recommend a sentence to the court, provide whatever information he wants the court to consider. The prosecutor also has a right to recommend a sentence to the court. Do you understand that?
Yes, Your Honor.
Do you understand that whatever anyone says at sentencing regarding what they think the sentence should be, it is just what it says, a recommendation. I don't have to follow that if I didn't think that was the right thing to do. Do you understand that?
Yes, Your Honor.
All right, well, do you have any questions at all about the potential penalties you face by pleading guilty to this reduced charge?
No, Your Honor.
You understand all the possible consequences?
Yes, Your Honor.
Do you still want to plead guilty?
Yes, Your Honor.
Have you had enough time to discuss this case with your lawyer and have him review the evidence with you, the reports, and answer your questions?
Yes, Your
Are
Honor.
you satisfied with the advice and counsel of your lawyer?
Yes, Your Honor.
Has he or anyone else made any promises to you about exactly what's going to happen at sentencing, which is inducing you to plead guilty?
No, Your Honor.
Have you been threatened in any way to plead guilty here?
No, Your Honor.
Are you entering your plea freely and voluntarily?
Yes, Your Honor.
So this is your decision?
Yes, Your Honor.
All right. Do you have any questions for me then at this time regarding anything we've just talked about? The rights you're giving up, penalties you face, what you're pleading guilty to? Any questions at all for me?
I have no questions. Your
Do you need
Honor.
any more time to talk with your lawyer before we go forward with your actual plea of guilty?
No, Your Honor.
I'm sorry.
No, Your Honor.
All right, then what's going to happen at this point, the prosecutor here is going to explain for me what she believes the evidence would establish at a trial if we did have a trial. I want you to listen to what she says, because then I'll have some follow-up questions for you, all right?
Yes, Your Honor.
Ms. Linden?
Thank you, Your Honor. Your Honor, had we proceeded to trial, the state would have submitted evidence to show beyond a reasonable doubt that these events occurred on February 27, 2025 in the city of Mentor on the Lake County, Ohio, and on that particular date, the defendant did operate a vehicle while under the influence of alcohol, drug of abuse, or a combination of them, and for purposes of this particular charge, that she had six or more prior convictions in 20 years.
Thank you. Ms. Burrington, were you able to hear what the prosecutor just had to say regarding what she believes the evidence would show if we had a trial?
Yes, Your Honor.
What, if anything, do you have to say about those facts as she presented them? Are they true? Did you do what she said?
Yes, Your Honor.
Very well, then, regarding the lesser included offense of count 1, charging with operating a vehicle under the influence of alcohol, a drug of abuse, or a combination of them, a felony of the 4th degree, what is your plea to that count?
Guilty, Your Honor.
All right, I have in my possession at this time a 4-page document called a written plea of guilty and judgment entry, which explains everything we've just discussed. Before I can accept your plea, I need to make sure you understand what's in this document and that you sign it here in open court. Now, my understanding is that before I came out here, you had a chance to review this document with your lawyer. Is that correct?
Yes, Your Honor.
Mr. Perez, is that accurate? Did you read this over and review it with Ms. Burrington and answer her questions?
Multiple times, yes, Judge.
Did she indicate an understanding of it to you when you did that?
She did, Your Honor.
Is that correct, Ms. Burrington? You understand the document?
Yes, Your Honor.
Do you have any questions for me about what it says?
No, Your Honor.
It also appears that you signed this document on the top of the last page. Did you in fact sign it?
Yes, Your Honor.
Mr. Perez, you witnessed that?
I did, Your Honor.
Ms. Linden, you as well?
Yes, Your Honor.
Very well, then, at this time, excuse me, the court will accept the defendant's oral and written plea of guilty. Let the record reflect the defendant was here in open court with her lawyer, advised of all her constitutional rights, and has made a knowing, intelligent, and voluntary waiver of those rights. Court also finds the defendant understands the nature of the charge, the effect of the guilty plea, as well as the maximum penalty that can be imposed. Give me 1 second, please. Finding this to be knowing, intelligent, and voluntary, the court will accept the defendant's plea. Find the defendant guilty of the lesser included offense of count 1, operating a vehicle under the influence of alcohol, a drug of abuse, or a combination of them, a felony of the 4th degree in violation of 4511.19A1. Count 2 will get dismissed at sentencing, but sentencing will be deferred. I'm going to order a pre-sentence report and investigation, a drug and alcohol evaluation, and I'll continue defendant's bond at her own recognizance. The conditions have been vacated, right, that were on there initially?
Yes, Your Honor.
Well, not all of them. She's not permitted to drive, but the EMHA and the GPS are taken all off, correct?
Yes, Your Honor.
So all the other conditions are still continuing, including no driving. So what all that means, Ms. Burrington, well, before we go into that, Mr. Perez, with the court having accepted the plea and your client pleading guilty, you're withdrawing the motion to suppress at this time then?
We do, Judge.
All right. So that'll be withdrawn. So what all this means, Ms. Burrington, as far as bond goes, I'm continuing your bond. There's nothing more you need to do except to comply with the conditions of your bond, which includes that you can't use any drugs or alcohol. You have to submit random urine screens. If requested, they have to be negative. A positive screen will result in your bond being revoked and a warrant being issued for your arrest. Do you understand that?
Yes, Your Honor.
Now, being released on a known recognizance bond means you have to show up at all future court dates. Well, being released on any bond means you have to show up at all future court dates. But if you're not, if you don't appear when you're on an own recognizance bond, that's a separate felony. It's the same degree of offense that you just pled guilty to that you can be prosecuted for. So it's obviously important you show up at all future court dates. Do you understand that?
Yes, Your Honor.
And the next court date is when, Mr. Shadowin? Sentencing?
October 27th, sir.
27?
Yes, sir.
So October 27th, and I'm sorry, I missed the time.
9:30.
October 27th at 9:30 will be your next court date, so you need to make sure you're here for that. You understand that?
Yes, Your Honor.
Okay. This pre-sentence report that I've ordered is a report that probation department puts together for my benefit to give me information about you and your background. The way they get the information is they're going to conduct some interviews with you. It's important that when you meet with them, that you're open and honest with them, because they're going to check and verify everything you tell them. If they learn you're misleading them in any way, they'll let me know that, and I would certainly consider that at sentencing. You understand that?
Yes, Your Honor.
Also, that report is necessary to be completed in order for me to even consider probation as an option. And in order for them to complete the report with you, the interview with you must take place. So it's important you show up on time when scheduled at the probation department for that interview, because if they can't conduct the interview with you because of your lack of cooperation or not showing up when you're supposed to, then they can't complete a report. And without a report, the law doesn't even allow me to consider probation as an option. You understand that?
Yes, Your Honor.
All right. So you're going to leave here now. You're going to go next door to the probation department, fill out some initial paperwork, and get your dates to come back. So make sure you do that, all right?
Yes, Your Honor.
All right. I guess that's everything. Ms. Linden, is there anything else?
No, Your Honor, thank you.
Mr. Perez.
I think you covered it, Judge.
All right, thank you.
All rise. I'm gonna get that J back off, see what happens. Yes, sir. Oh, mute it, should.
Hit mute. Do nothing
Here's
else.
mute. Test, 1, 2, 3, test, 1, 2, 3, test, 1, 2, 3, test. Now you want me to get J back? The J back off?
on your computer?
Yes, sir. Yes, sir.
I'm gonna do both of them.
Mine.
You turn it off first.
Let's see. Let's see.
Playback audio off. Huh?
I gotta fire my computer right here.
Well, let me see if I can do it.
Okay, sir. I fired.
Let's see if it works. Don't do anything
No,
on
I'm
yours.
not doing anything, sir.
All right.
Can you hear us, Amy? 1, 2, 3, test. 1, 2, 3, test. Can you hear us, Amy?
You cannot. You can. So right now you're hearing us? Right now you're hearing us? Amy? You're hearing us through the microphone or not just through down the hall?
She's hearing through the microphone, sir. That's not the way it's supposed to work.
Make sure I hit the right button. VAC audio off. You're hearing us right now, Amy?
Amy, you can hear us? Yep.
Might stand you hit yours.
All right, let me see. All right, let's try this.
Mine says, yeah.
Mine says it fired. Congratulations, you fired back off.
Mine said that. Mine said that too when I hit it. I thought.
Amy, can you hear me? 1, 2, 3. Amy, can you hear me?
Hello?
Can you hear me, Amy? You can still hear us. Then what good is that for?
See, mine says that. Congratulations, you fired the back off event. Amy, are you hearing us right now? 1, 2, 3, 4, 5.
You can hear the judge, Amy? And still hear. So that's he's got to fix that.
Yeah.
That's got to be.
Because it even says that. I'm gonna leave my screen just like this.
Yeah, I'm going to leave it all on. What I'm going to do is, yeah, FTR is not playing, but YouTube's fired.